There were also substantial delays in coming to a decision on disclosure and on reviewing the decision at internal review. The worst cases were 29 months NOMS, Burr, the old DTI, BIS 21 months, Greater Manchester Police 15 months, and so on. These kind of things are absolutely fatal to the legislation. They kill off straight away most of the proposed benefits of the Act: the opportunity to participate, the opportunity to try and influence decisions, the possibility that disclosure may enhance public confidence in public authorities and trust, because behind such delays is assumed to be obstruction on the part of the public authority, certainly in the latter cases of internal reviews and so on. I think here is where we need remedies very urgently. The Commissioner is addressing the backlog. He's treated it very seriously. We'll wait and see how successful that's been. The next thing I think we need to see is not to have whole packages of documents held up until every document has been fully considered and taken through the exemptions. The fact is, under the Act, there's a provision for extending the timescale when an authority has to consider the public interest test. But that only permits the extension for the particular information to which an exemption with a public interest test applies. It does not apply to the straightforward documents which are obviously disclosable or for which no public interest test applies. Those, by law, have to be disclosed within a 20 working day period, but that principle is rarely followed in my experience, and I think what we need to see is the Commissioner enforcing disclosure of the documents which are not entitled to public interest extension as soon as the time limit expires. The third thing I think we need to see is a requirement for authorities to report annually on the number of times on which they have not managed to comply with the statutory time limits, so that they are actually having to draw attention to this problem, that we're not limited to the data that we have, which is central government only and doesn't apply outside of central government, and we also require authorities to address themselves to explaining why that has happened and what they're doing to try and prevent it. And I think we need new statutory time limits. There is no time limit for internal reviews under the UK Act, unlike the Scottish Act. And there is no time limit for how long an extension can be taken for on public interest grounds. And so what we've had from NOMS, for example, is 12 successive monthly extensions taken. And so after a whole year, they're still considering the decision. That shouldn't be permitted. Other measures I think we should see. You can't bring an offence you can't prosecute an authority which has deliberately destroyed records after they've been requested, unless prosecution is brought within 6 months of the offence. That was highlighted by the Climategate affair, but we highlighted it before that and tried to get an amendment passed last year, which the government didn't accept. I think we need better rights of access for the next of kin of people who've died. At the moment, they have some rights of access to medical records, where the medical records relate to the cause of death, but no access to any other type of record. And what has happened is the FOI exemption for breach of confidence has been held to apply to the records of somebody who's died after death, withholding it quite properly from the general public, but also from the family. Whereas the next of kin have rights to medical records, they don't have rights to social work records, social care records, very relevant in a lot of cases. We have very poor rights of access to documents which have been read out in open court. Somebody applies for them, they're covered by the exemption for court documents. There's no public interest test. The fact that they were read out in open court is not relevant. And finally, we have had, I think, a bizarre tribunal decision which holds that anonymized data, fully anonymized data, from which no member of the public can infer the identity of the subject, is still personal data under the Data Protection Act. And where it is sensitive personal data, that is, it relates to somebody's health, racial origins, sexual orientation, and so on, it simply cannot be disclosed even in anonymized form, because it's still personal data, because the authority can still identify who the individuals are. If the authority can track back who is involved, then it's still personal data, and I'm sorry for those of you who are not familiar with it, but those who are, you'll realize what I'm talking about. It can only be disclosed if there's a condition from Schedule 3 of the Data Protection Act, which is virtually impossible to obtain for this type of data, in addition to the normal requirements. The final thing I think we need is more action on disclosure logs. This is what I mean by it. There are now hundreds of decision notices against public authorities. This is just a little summary of part of it from the Information Commissioner's site. Every decision notice is bad news for a public authority. It means whether, rightly or wrongly, they've withheld information or acted in some other way which has dissatisfied the requester. Even when the decision notice upholds the authority, there's nearly always a rebuke somewhere in there for the public authority on a technicality. So if you look at what's published, the greatest source of information about individual authorities are this collection of rebukes. If somebody wants to know the record of a particular public authority, it's focused. The public record focuses on the rebukes. Where's the good news? Where's the information they've disclosed? Well, it doesn't feature in a decision notice usually. It may do in passing, but noted. And if they've just given the request everything the requester has asked for, usually that just disappears from public sight. Now, public authorities have been encouraged to publish disclosure logs highlighting significant information which they've released. This is an example from the Ministry of Justice's disclosure log. I haven't edited this. These are the 4 entries which extend from the present day to this time last year. So there's 4 entries from the Ministry of Justice with its vast field of responsibilities in the whole year, despite the thousands of requests it deals with. That's all it does to publicise. It's good work. This is Scarborough Borough Council, and this is a partial extract from their March 2010 disclosure log. And it goes on, you know, I'm not scrolling it. The March disclosure log goes on. You can see every request and how it's been dealt with. Not just those which have led to disclosures, but those have been refused. Very valuable. You can see what they've released. You can see when they've said, I'm sorry, we're not prepared to disclose. I think there's a legitimate exemption. We're not prepared to disclose. That too is valuable. But you can see what the authority has done. So it's a counterbalance to the bad news. I think what we should be getting is authorities should really be asked, consider for themselves, what is it that they have disclosed annually during the year, and then they should say, what of that information should we publish proactively? What of the information which we have disclosed should we regularly be disclosing? And I simply just show you this from the Department of Health, but it's the Office of Government Commerce's Gateway Reviews on the NHS IT project. It was a subject of a series of tribunal decisions, hotly fought. Tribunal ruled they had to be disclosed, and the OGC and the Department of Health have published a whole list of them now. And they go down page after page after page, and you can read these, and it's a fabulous insight into the way in which the process is done and the problems found. And it's good news for the public authorities concerned. I think we should be seeing more of this, and there should be a process to encourage it, not simply left to random.